This video is to generally describe the anatomy of a lawsuit. I'll be concentrating on the courts in Nassau and Suffolk County, New York. This video is intended to give general information to the viewer. This video is not intended to give legal advice, nor should the viewer believe that it constitutes an attorney-client relationship. For specific questions or to retain my services, you may either email me at attorney@mampc.net, or you may call me at 516-295-9061. This video is being published in July of 2020. Before I review its structure, it is important to understand the purpose of a lawsuit. A lawsuit is a process allowing a plaintiff or a petitioner to file a complaint or a petition for a remedy or damages from a defendant or respondent. A complaint or petition may take many different types of forms. A plaintiff may claim a violation of an agreement, that he or she wants a divorce, an eviction, or that the defendant physically hurt you. A remedy or damages may be money, an order directing specific performance, or a determination, example, that the decedent's last will and testament is valid. Not all courts have jurisdiction to hear all cases. For example, a small claims court only has jurisdiction to award money damages up to $5,000. The Nassau County Surrogates Court only concerns wills, trusts, and estates and may not award, for example, child support. Assuming a court has jurisdiction to hear a case, to commence a lawsuit, a plaintiff must file and serve the defendant a notice that he or she commence a lawsuit. This is called a summons. A summons must be served on the defendant. Service is a formalized or statutory method of delivering the papers. Once the court has jurisdiction, the defendant must appear and answer the charges filed by the plaintiff. An answer may be an admission, for example, I did it, a denial, a request for additional information, or it may include a counterclaim. A counterclaim is a request by the defendant for a remedy or damages against the plaintiff. An answer may also include an affirmative defense. An affirmative defense is a defense that must be proved by the defendant. An example of an affirmative defense is a statute of limitations, which means that the plaintiff did not timely start the lawsuit. In some jurisdictions, there is a discovery process. Discovery means to obtain information that is relevant for the parties to prove their cases. Discovery may be a request to expand or explain the complaint and answer. Discovery may also be a request for documents. It also may be an opportunity to ask the adversary questions, either on paper or orally through a deposition. When the parties are ready for trial, a court generally holds a conference to discuss the nature of the lawsuit and whether a settlement is possible. A settlement is where both sides agree on a remedy. For example, a settlement on a breach of contract case may be to accept a lesser sum of money in exchange for dismissing the lawsuit. The court conducts a trial if the parties are unable to settle the matter. A trial is a formal process whereby each side has the opportunity to present and examine facts before the court. Each side has a burden of proof. The plaintiff has the initial burden to present facts in support of its claim. The burden then shifts to the defendant to present his or her facts in support of his or her denial. Generally, the burden of proof in a civil case is by the preponderance of the evidence, compared to the burden of proof in a criminal case, which is beyond a reasonable doubt. The fact finder in a trial may be a jury or a judge. A fact finder is just that, an individual who determines what happened between the plaintiff and the defendant. Once the fact finder establishes the facts, it is the judge who applies the facts to the law. If the facts establish that the plaintiff met his or her burden of proof pursuant to law, the court will then issue judgment in favor of the plaintiff. Judgment may be money or an order to do or not do something. This is also called an injunction. New York has a right of appeal. This means that if an individual does not like the order or judgment, he or she may have an appellate court review the facts and law. If the appellate court agrees, it affirms the lower court's ruling. If it disagrees, it may reverse, or it may modify the judgment. Finally, it is not up to the courts to enforce a judgment. A judgment is enforced through the executive branch of government. Generally, this is either the sheriff or the marshal. Furthermore, even if not enforced, a judgment alone has a detrimental effect against an individual or entity. A judgment places a lien on real property. A judgment lowers a credit score. A bank will generally not loan money to an individual who has a judgment against him or her. For more legal information, or if you need legal representation, you may either email me at attorney@mampc.net, or you may call me at 516-295-9061.